Supreme Court ruling in the appeal of the judgment of Mr. Justice Humphreys in this case. The case is actually called IRM and Others versus the Minister for Justice and Equality and Others. Is quite extraordinary in lots of respects, but in this particular respect it's fascinating that at a technical level the court has rejected the state's appeal, and that on the face of it looks like that, doesn't it? But actually that's entirely meaningless, because the state's appeal primarily was about, the case was an immigration case, and it was about whether or not a particular man ought or not to be deported. And that's the part of it that the court has shot down, the state's application to prevent this. And the reason that they shot it down is that it's no longer relevant. It's moot. The man's been deported. It's all over. Every other aspect that is of importance, all the questions, the reasons that the government actually appealed this case, because they weren't interested in this man. What they were interested in was the findings of Mr. Justice Humphreys in relation to the unborn child in particular, particularly those, because he had identified all of this raft of rights in statute, in conventions, in common law, and in this constitution itself. In Article 40, before even Article 40.3.3 was introduced in 1983, he said there were rights there in Article 40. And he also said that the article introduced as a result of the referendum in 2012, which is Article 42A, which is the Children Amendment, he said that applied to all children. And the court, in a most remarkable way, like almost like picking off with a high-powered rifle, shot down every single thing that Mr. Justice Humphreys found that might give any additional right to the child other than the right to life in Article 43.3. And the implications of that are quite staggering, but we'll go into that later. But I just want to talk about how they did this and because it's remarkable. It appears to me that reading their judgment that they have gone through the state's arguments and simply co-opted them and affirmed them and rubber stamped them. And in some cases this leads the court into serious errors because the state is not honest. And I want to explain a little bit about that as well in a little while. But it's quite amazing. A lot of the time they're playing games with language, semantics. And they talk about, for example, the word unborn and what it means. And it's almost like reduced to a kind of a joke. It says here, it is undoubtedly the case that the phrase the unborn is unusual, as has been pointed out previously. As Hardyman J. memorably said, the unborn what? The unborn what? Who but a judge could possibly have any doubt about what the unborn is? The unborn is a baby, is a child. The unborn baby, Mr. Justice, whatever your name is. Clearly, as Gagan J said, it would appear to mean the as yet unborn, or as a reference to future existences. It is difficult to disagree with this view, the judges say. Well, actually it's not, because future existences, there are no future existences at issue if there is a baby there in the womb. The existence is already in train. So this is the kind of language that they go through, and it's quite staggering when you see it all put down in front of you. In relation to the assertion of of Justice Humphreys that Article 42, all children, refers to, as you would imagine correctly, they say no, it doesn't mean all children. So this doesn't mean the unborn, and the unborn therefore is not a child. Is more or less what they're saying, but they don't quite say that. They fudge around these things. They don't really make very good arguments, and sometimes they make very bad arguments indeed. And I want to talk a bit about one of those really bad arguments, because there's one part where the court really shows itself up as deeply, deeply ignorant. And that's when it's actually talking about in one of its arguments, it says that one of the reasons it offers for the unborn not being included in Article 42A is that it says, the court says, Article 42A has a provision for the voice of the child. In other words, and it has, it allows for the possibility that a child would be able to speak in proceedings relating to the child itself. And the court says, the judgment says, this can therefore only apply to children who have been born. And on the face of it, that actually appears to be true. I mean, it actually reads that it's actually like a sensible thing to say. The problem is that just as you might say the same thing about a child who is 1 or 2 years old, a child of 1 or 2 or 3 or 4 would be no more able to express his or her wishes in a court of law than a child of 12 weeks gestation. The article, there's no doubt whatever, is intended to refer to the child, to the unborn child. And I look again later at some of the evidence that we have for that this is all linked in. Article 42A is intrinsically linked to the UN Convention on the Rights of the Child, which expressly states that the unborn child is a child. So the Supreme Court has basically sought to go along with the government's position, which the government has now formulated, having never expressed it before. No Irish government has ever said this before, but this one is saying it, in order to clear the way for a referendum to dispose of what would then be the only remaining right of the unborn child, which is the right to be born. And I would say to people that if you read this judgment and consider that we're looking at a court which is supposed to be the guardian, the custodians of the Constitution, that we need now to consider the possibility that our Constitution remains completely unprotected. And that means that we, the people, are unprotected.